jurisdiction may allow the substitution and let notice go to the legal heirs of the OP4 my lords. OP5 has also appeared.
Where is your application?
My lords, IA number 28 of 2024.
A number 28 is not there. Is it there?
My lords,
That is
IA
in
Yes.
CMA.
Just.
No.
Just. When did he die? Or she die?
My lords, on
There is
30/12/2023.
There is delay.
There is delay then.
Yes.
All right.
My
The
okay.
this application has been filed IA number 28 of 2024. This application has been filed for substituting the opposite party number 4 with his legal heirs died on 30/12/2023 during the pendency of this application, comma, leaving behind the legal representatives as mentioned in the schedule. Stop. Considering the facts and circumstances and the nature of relief sought in the main application, which is of the nature of restoration of what?
My lord of CMAPL
Restoration CMPL number
MPL 870.
Restoration of
817 of
restoration.
CMAPL and REIT appeal.
Why restoration of restoration? What is this?
Not there. Clearly, my lords, the
No,
CMAPL.
So
My lord,
notice. Sorry.
my lord, notice was already issued, my lord.
What?
Notice was already issued, my lord, in the CMAPL.
In the present CMA.
Present CMAPL.
870.
You are
is
appearing.
my lords.
My lord,
All right, then we are
My
allowing.
my lord.
This application is allowed that names of the legal heirs as mentioned in the schedule be substituted in place of the deceased OP number 3.
My lords.
So should we allow the restoration application?
And it's a restoration of a restoration application dismissed for default in a REIT appeal, my lords. My lords,
Maybe
the ground taken by them is that the counsel who was earlier appearing in the CM appeal is a lower court practitioner, and that's why he could not appear, my lords.
That is not a ground.
My lords. And secondly, their ground is that they have no explanation why they have not filed
When
the,
was the WA filed?
my lords.
in
WA, my lord,
W-
filed
2016. So we
2016.
will allow your application subject to imposition of cost.
lord,
Uh,
as a loss you may consider, my lords.
20,000, not less
My
than that.
lord,
This is 2016 matter. You want us to restore 2016 matter. How can we? Twice dismissed for default.
No.
If you want, we can. The CMAPL, this application has been filed for a restoration of CMAPL number. What is that?
Number 817 of 2019.
8171 of 2019.
19 months.
Stop. After the said restoration application was filed in 2019, the present application has been filed 3 years thereafter in 2022. Stop. The previous restoration application, that is CMAPL number
817 of 2019.
817 of 2019.
No. The earlier one, which
The earlier one, my lords. CMAPL 817 of 2019.
817 of 2019
19.
was filed for a restoration of WA number
549 of 2016.
549 of 2016.
In that restoration application also, there is a delay of 42 days, my lords.
Considering the conduct of the petitioner in pursuing the writ appeal, which stood dismissed for default initially, and thereafter the restoration application also came to be dismissed for default, this application for restoration of CMAPL number so and so is allowed subject to payment of sum of rupees 20,000 in the account of yes. The account of petitioner equal portion to the respondents and equal proportion.
For judgment item number 1, W1742 of 2023.
Opinion that the appellant petitioner's claim for compensation can be determined only in accordance with section 16(3) of the Telegraph Act. We do not find any illegality in the impugned order. Accordingly, we do not find any merit in this appeal, which is dismissed. There are some typographical errors.
Item number 2, WA3103 of 2023. 3103 of 2023.
We have a point that the finding recorded by the learned single judge that 50% cutoff marks was fixed by the selection committee, in our opinion, is erroneous and not sustainable. We reiterate that the stand of the university in the counter affidavit that 50% cutoff marks was fixed was based on communication made by one of the members of the selection committee, that is former vice chancellor who was chairman of the selection committee. We are of the view that the impugned judgment and order dated passed by the learned single judge in WPC number 21396 requires interference, as the same cannot be sustained. The impugned judgment and order is set aside, and the writ petition stands dismissed. The writ appeal is allowed.
That this matter may be treated as the PIL. I have filed this writ petition that was not registered as the PIL or writ petition, Your Lordship. I might file another IA to ignore the defects of the.
What is your relief?
My Lord?
What is your relief?
My relief, Your Lordship. I pray. Earlier in the year 2017, there was a notification was published.
No, why are they saying that it is in the nature of PIL?
Because the public, some publics has given the statement, representation before Lordship. That by seeing this, the registry is marked as the treated as the PI.
How the registry can say that? All right, don't make a mention. I'll see.
My Lord, my Lord.
Don't give your slip.
My here, Your Lordship, the landed district judge is going to inaugurate on
Please.
7th, Your Lordship.
Inaugurate?
That is on 7th of coming month, August, Your Lordship. There is urgency in this matter.
What inaugurate?
My Lord,
What is to be inaugurated?
in the civil court building, Your place of the civil court building, but ignoring the 2017 notification. This is my sole grievance before Lordship.
Who are you?
I am the public, one of the public of the particular block
And you are
headquarters.
opposing inauguration.
My lord?
You are opposing inauguration.
No, no, no.
Then
No, I'm not, but because there was already inauguration work is over. Already joint site selection committee has selected this place. Ignoring the 2017 notification and the joint selection report, your lordship, select committee report. Again, in 5/7/2024, another notification was published by the Law and Justice Department
for what?
for establishment of the court,
Which court?
Junior Division Civil Court, come JMFC.
Where?
Where at block headquarters at Kota Kosagunda.
What is your problem?
My problem, your lordship, already site selection was there, and there is a center of the.
How are you agreed?
Because my lord, there is all the block, all the officials,
How are you individually affected?
not individual, my lord. All the
Then-
publics has given the.
Therefore, the registry is saying it's a PIL. And whether it is a PIL or not, we will take up your case.
My lord,
This bench will take up your case.
my lord,
And if required, we will sell. We are discouraging such applications being filed before this court. We will impose cost.
my lord.
Unnecessary litigation
No, my
being
lord, there
filed.
is no litigation.
We will take up.
Okay.
Give us slip.
Okay.
Beg your pardon, my lord. Milord, as your lordship has directed yesterday, so far as the GST and royalty matter, your lordship. Your lordship, I am giving here the list along with the Honorable Supreme Court's order, judgment, your lordship. And your lordship, the last state's order, your lordship has adjourned, was pleased to adjourn all these matters to 12th September. If your lordship, it might be,
It will come from 12th.
your lordship, as your lordship, please.
Lordship, pardon to make a mention, Lordship, I am on VC.
Yes.
Lordship, urgency, Lordship, this matter is, Lordship, assigned to Honorable Single Judge. But due to judicial order, Lordship, my matter cannot be listed before that court, Lordship. So, Lordship, I have urgency matter, Lordship, disengagement matters.
Judicial order could not be listed.
Due to judicial order, Lordship, because my matter cannot be listed before that court, Lordship.
What do you mean by judicial order?
Because there is a order, Lordship, my matter cannot be listed in court number 11. In a particular court number 11. That's why.
My lord, I may be pardoned to mention, my lord. Item number 3, my lord, it was listed yesterday. And I have sent a junior friend to mention this matter because, my lord, on Monday, my lord, while I am plucking the flower in a ladder, I fell down from the ladder. I have sustained injuries, my lord. Therefore, to recover, my lord, for recovery, my lord, some time is
We will
required. my lord.
adjourn, don't worry. Don't worry. If you would have.
And my lord, I am 1963 born.
All right. I am also
I am
1963 born.
aged.
You are not aged.
For recovery, it will
Alright.
take time.
It's a different matter. It's a different matter. We will adjourn the matter. Why are you worried? You could have asked any of your colleagues.
Yesterday there was a mention.
Then-
It was listed today, my lord.
It might have been listed, but according to you, it was mentioned. Did we decline?
For next week, my lord.
No, but when we adjourned to today, she did not say anything. Had she said that she has got injured, for the time we would have done
We
it.
never do it. We never decline adjournment on when the adjournment is on such grounds.
Your lordship may kindly adjourn to next week. my lord.
We will adjourn.
But she's telling the 63 once is old, then I am dead.
This is for the purpose of adjournment. There are
Therefore,
No. Recovery
therefore,
process is
Mr.
delayed.
Mohanty, you should hold some workshop on this. Why such mentionings are being made?
the ground of
I'm
age.
63, what is?
Because of age, my recovery process is delayed.
No recovery process. Don't never allow this thought to enter into your mind that you are aged. All right, we are adjourning. But
May it please,
yes,
may it please, my lord, there is a matter on the board, item number 40, my lord. On the last occasion, my lord has directed to list this matter along with 2 other similar matters, my lord. Though I have supplied the numbers, my lord, inadvertently it has not been listed today. My
Madam,
lord, today,
I'm sorry, you had not supplied the numbers.
Yes,
till
my
the
lord,
time
my
you
lord, I have-
signed the order. Anyway, you have given it now, we'll see.
My lord, let it come tomorrow along with other two matters, my
We'll
lord.
see.
I'll supply.
Yes.
Yes,
We'll-
ma'am.
we'll see.
Madam, item 53. Item 53 may be taken up today at 2 p.m.
Right.
Neat admission, madam. Neat UG admission.
We'll
MBBS.
see, we'll take up the matter at 2 p.m. or 4 p.m. We don't know, but we'll take up.
Okay.
May I be pardoned to mention item number 48, your lordship, for the petitioners. It's a tender matter, your lordship, and we are apprehending that the matter might turn infructuous. If your lordship could fix
We'll take up. We will take up the matter. Please inform someone, the other side.
Yes.
We may take up the matter at 4.
Sir,
There is a reference to that teaching.
May you mention at 2.
there are 4 matters.
So what if we take up your matter on Monday?
And as your current lordship finds it.
Monday 2 p.m. Monday 2 p.m.
Item 48.
बेसी नाही का 2 PM से ना आपण एका करता है. अच्छा. And that need one two matter mentioning examination matter. The year responses start unless of course there are.
You are in need. Who is there in need? No.
Where is
Item number 1.
May I please your lordship? My lord, on last Wednesday, your lordship has been pleased to allow my amendment petition, my lord.
Water constants.
No. There is one problem in arising, lord.
Name of the petitioner is Amit Birla.
Amit Barla.
Amit
Barla.
Barla.
My lord, the
And
brown.
council is Ghanshyam.
Yes, by myself, Ghanshyam. My lord, the problem is arising, my lord, that after amendment of my petition on Wednesday, I have filed my consultative petition, and it has to be put up before the ADR for correction of some page marking as well as something else, which could not be done because I was absent on Monday as well as Tuesday. So I pray, let it be sent to the ADR at least today, so let it I can correct it, and it will come tomorrow if my lord may please.
Deputy Registrar.
corrections also, and they want to remove a defect. They have done. I think not that this is.
I requested on behalf of the petitioner, let this matter on 1 week.
Item number 2.
It will taken out tomorrow, will not?
1 week.
1 week.
Item 2.
Item 2. Made, please, my secretary. Lord, there are 3 matters, my lord, challenging the wires of Rule 7 as amended in 2023, madam.
7 or
23. Orissa Engineering Service Method of Recruitment and Condition of Service Rules Amendment 2020.
Get.
readings are complete.
Readings are complete. Lord, to take your lordship to a little background so that your lordship may able to, your lordship may give me some indulgence for few minutes. My lord, Odisha Engineering Service Method of Recruitment and Condition of Service Rule 2012 came into force in the year 2012. I have annexed this to my writ application at page 45.
Yes.
May I take your lordship to page 45, more specifically to page 47. This is by way of direct recruitment, my lord. My lord, has your lordship got it, my lord? Page 47.
Yeah.
Your lordship sees part 3, clause 6, my lord.
Yeah.
Eligibility criteria for direct recruitment. In order to be eligible for direct recruitment to the post of assistant executive engineer in the service, a candidate must satisfy the following condition. My lord, we are in B, my lord, a minimum educational condition. He must have possessed a degree in engineering or an equivalent qualification from any university or institution recognized by the government, or he must be an associate member of the Institution of Engineers of India. Then, my lord, your lordship may skip over the rest, my lord. Then come to clause 7 at page 48, my lord. Then 7 provides the selection by the commission. The government decides to fill up, when the government decides to fill up the vacancies in the post of assistant executive engineers by direct recruitment, government will communicate the number of vacancies in the post along with reserved vacancies thereof proposed to be filled up. The commission on receipt of the requisition shall in such manner as it thinks fit shall invite application from eligible candidates. Your lordship, eligibility criteria is, my lord, degree in engineering. Then the commission, after receiving all applications, shall take steps to select candidates in the manner given below. Selection shall be based on career evaluation and objective type written test and via voice test. Then you have a career evaluation shall be 50% and objective type written test will be 40%. Then the interview is 10%, my lord. Then, my lord, in 2014, it underwent an change, my lord, that is page 53, my lord. Rule 7 was amended. The commission on receipt of the requisition shall take steps to select candidates in the manner. Selection shall be based on objective type written test and via voice test. Weightage and objective will be 90% and 10% will be via voice. The percentage went out, but the career evaluation was given a go by, and then it was prescribed that it will be way of a written test carrying 90% of the marks and 10% for the via. Then this continued, my lord. Then, my lord, in 2023, my lord, 2021, my lord.
This happened when?
This happened, my lord.
No, the first amendment.
The first amendment to 31st October 2014.
Yes. Then?
Then, my lord, 2021, the next page, my lord, page 54. This is Amendment Rules 2021.
Yeah.
Then at page 55, my lord, as your lordship got it, my lord. Then for the first time, my lord, in Rule 7, my lord, clause 4 of the amendment at page 55, my lord. Has your lordship got it? No?
Yes.
May I please? In the said Rule 6, for subrule 2, the following subrule shall be substituted, namely the commission after receipt of the application shall take steps to select the candidates on the basis of highest of the valid gate score of preceding years and the date of advertisement. marks secured in career evaluation, objective type written test, and viva test, the words and expressions valid gate score shall be substituted. That means for the first time in 2021, instead of eligibility test written or viva, it was prescribed that it must be based on the valid gate score. Then that means the Public Service Commission has not to do anything now, and only to prepare a merit list on the basis of the applicants, those who are qualified in the gate exemption. This was challenged before your lordships on several grounds. One of them is that it is contrary to Rule 6, and it is not granting a level playing field to all eligible candidates to be considered by the Commission, and also that the Union Public Service, in spite of the objection of the Union Public Service Commission, this amendment has been carried on. This was hard, and your lordship was pleased to strike down the amendment, but on the basis, though the questions were raised, my lord, it was only answered on the basis of the rules that OPSC consultation is a mandatory consultation, and OPSC's difference with OPSC ought to have been taken care by the cabinet in accordance with the prescribed mode under the Constitution and the rules. Then, my lord,
Which is that judgment?
Annexure 6 is the judgment, my lord.
Reported.
Not been reported. It is reported. It has probably been reported.
All right. All right.
My lord,
Yes.
then why the matter was carried to the Honorable Apex Court by the state government, my lord. And while the matter was pending in the Honorable Apex Court, the state government came out with an amendment of 2023 and made a submission before the Honorable Apex Court that in view of the fact that there is a subsequent amendment, this the SLP has become infructuous. And I will place those observations of the Honorable Apex Court.
Whether in the next amendment, for the next amendment, OPSC was consulted or not?
Malad?
For the next amendment.
Yes, yes, it was consulted.
OPSC was consulted.
Yes, and like OPSC has also filed a counter, though it was served yesterday, but admitting that they suggested certain things and government has carried it out. So that shows that it has been consulted. Then came, Lord, then this 2023 amendment, the Supreme Court, Honorable Apex Court allowed the state government to withdraw this SLP. Then came 2023 amendments, my lord. That is
Yes, 2023.
My lord, that will be available, I think, in page 117. Yes, ma'am. That is 26 September 2023. That is page 100, running page 170. Well, this is under challenge, my lord.
Page
170. May I draw your lordship's kind attention to Annex 7, page 170.
Yes.
Has your lordship got it?
Yeah.
Clause 2. The Odisha Engineering Service Method of Recruitment and Conditions of Service Rule 2012 in Rule 7. For Subrule 3, the following shall be substituted. Then the Commission, after receipt of all the application, shall take steps to select the candidates on the basis of valid graduate aptitude test in engineering score and interview. Merit shall be prepared on the basis of aggregate marks secured in valid graduate aptitude test in engineering score carrying 90% weightage and interview carrying 10% of weightage. This clause we seeks to challenge. Then in order to appreciate our contention, but your lordship knows, and it is common knowledge, that GATE exemption is not a mandatory exemption, and it is not conducted by the either by the central government or by the state government. Certain group of institutions have come together and has formulated a set of rules for admission to the postgraduate course in engineering. And that examination score is taken as the basis for the students to be admitted to the postgraduate course in those institutions. And to make it more clear, my lord, we have in page 57 annexed a public notice by the AICTE that AICTE is deciding to make GATE as mandatory exit exemption. AICTE has not taken any such decision. This is issued to clarify all stakeholders. All India Council of Technical Education clarified that it is not mandatory and we are not contemplating it now. Then, when I be that as it may be, the challenge now before your lordship, my learned friends will develop other points. Mr. Pandit and Mr. Rautre is there. I am confining myself to the submission, Lord. Rule 6 has not undergone any change.
Yes.
Over all these years, and still as on today, the eligibility criteria is the degree in engineering. So, my first contention before your lordship is that if the eligibility condition is degree in engineering, the natural consequence is that the consideration must be from amongst those eligible candidates. That means all candidates possessing degree qualification are entitled at least to be considered for such post, because, and more so in view of the fact that it is a public employment on the state. Now, by prescribing that valid GATE score 90 marks and 10% by the interview, basically those students who have not appeared or are not desirous of pursuing higher studies or in circumstances where they cannot afford to.
Once it is known to them,
yes,
that for seeking employment in government service, GATE score is required, then in addition to their aspiration to go for post-graduation, for this also they may decide to take up GATE.
My submission is I respectfully disagree with the proposition. Basically, my lord, my submission is that There may be several circumstances of somebody appearing or not appearing in the gate.
There are two situations. There are two situations.
Yes.
I must explain it. The one situation is that today the government decides that gate score shall be the valid basis for selection, or that shall be compulsory today. All right. And tomorrow the selection process is initiated. Then there must be numerous aspirants who are not knowing about it.
That is one of the.
Just a minute. So they stand excluded. This is one. But suppose today amendment is made and 1 year thereafter or 6 months thereafter, a selection process is undertaken, which provides that you must have gate score. So the candidates had the knowledge that there is a rule to the effect that they must have gate score, and if they were at all interested in engineering service in the state of Odisha, they could have participated in the gate score for this purpose also. For them to appear in gate score will be serving dual purpose of getting admission in postgraduate institution and employment in the government.
That is, I am not in quarrel with the state government so far as their power to prescribe the eligibility criteria is concerned. But that is why I told my lordship, state government is at liberty to prescribe any eligibility criteria.
This is not an eligibility.
My submission before your lordship is that if you prescribed an eligibility criteria, then you must give equal opportunity to all having the eligibility criteria to be considered. To segregate.
Prima facie, I don't know what decision we will be taking, but prima facie we are of the view that this gate score is not an eligibility criteria. Eligibility criteria is there in Rule 6. Rule 7 prescribes for the selection process. And in that selection process, it is mentioned that you should have gate score.
Then your lordship sees the fallen. What that must be a rational objective to be achieved. If the objective to be achieved is to take the best from amongst the degree engineers, not from amongst the gate qualified degree engineers. I am confining it to from amongst the degree engineers. Then, my lord, the government is free to prescribe an eligibility criteria that only postgraduate students would be considered.
They can do
one minute. Or it may prescribe that only those candidates who have qualified in the gate score would be eligible to apply, and the selection would be done on the basis of the gate score. Whether that would be sustainable in view of Article 16 or not, that is altogether different thing. We are not there. I am telling that once you prescribe an eligibility criteria without changing the eligibility criteria, if you exclude a group of persons having the eligibility criteria.
Which person has been excluded?
But only graduate engineers. If eligibility criteria is that of graduate engineers.
That is not C. The eligibility condition is engineering. So instead of holding an examination.
Yes, there are two types of discrimination. One is by intent and another is by impact. But if you confine it, the degree engineers who has 90% of the marks to be reserved for persons, those who have qualified in 90, then you are leaving open for direct engineers who do not have gate qualification, only 10% of the marks. But there is no bar to apply. But effectively, you are excluding from consideration 90% of the mark in respect of the students, those who have not appeared in the gate examination. So, indirect impact of the amendment is, it creates a class in between a class. That is my submission.
If the government decides that the selection process shall be through a written examination.
Yes.
To be held by a body.
Yes.
May not be OPSC.
No.
The OPSC may decide that it should
No,
be
even
held by
OPSC.
So held by a body, any body other than OPSC.
Right.
And the score
yes.
In that examination shall be the basis for determination
Yes.
of selection. What is wrong in it?
Well,
what is wrong in it?
Like, there is no written examination. It is gate, those who have appeared.
Gate is a written examination.
Gate is a written examination for those. It is not a mandatory for degree engineers. It is only necessary. It is never a mandatory exemption.
See,
nor it is a higher qualification.
The simple interpretation of Rule 6 read with Rule 7 as amended is that those who have degree in engineering are qualified. 1, 2, for the purpose of determination of their merit, they should have the gate qualification, gate score.
Yes.
All right. And gate score, because the state government is of the view that the gate score is a reliable score, and therefore, based on that score, the merit list shall be prepared. That is the
Well, these are my submissions. Then the objective must be to select out the best candidate for the public employment. Well, a person who has not appeared in gate score or who has already is a postgraduate may not be required to appear anymore in the gate score because he has already a postgraduate qualification in engineering. So therefore, but what indirectly it is being done is, my lord, it is substituting Rule 6 by that of Rule 7. Rule 7, instead of the selection method, my lord, makes it an eligibility criterion. And it is hit by both intention and the impact.
Yeah.
Then the second is, my lord,
is there any bar for a candidate to take gate examination if he has PG qualification?
may I negatively put it, my lord? Is there an option with the candidate to take the gate score or not? If that is question, my lord, then my answer will be yes, I have an option. And my lord, your lordship takes into a case where a person is not capable of affording postgraduate education. My lord. Postgraduate education is not free in this
Our
country.
question, see, your submission appeared to be correct when you said that a person who is already having PG qualification, why should he apply for GATE? All right. My question is that whether a person having PG qualification is disqualified from appearing in the GATE examination. This is my question.
If it is an entrance test for the PG, my lord, will he appear again in the PG test for an entrance examination?
See, Mr. Mohanty, we are not going by logic. We are going by the scheme. Like whether in the scheme of the gate, a person having PG qualification can still appear for the gate because this method has been prescribed under the rules.
And I am giving you this scheme.
And if it is found that they are not eligible to appear for the gate examination, if such candidates, then it otherwise eligible, then we will have to consider that aspect.
No, that's
Are we
one aspect.
clear?
Yes. That point has also been taken, my lord. Then the this, I am leaving those points to be developed by Mr. Rautray and Mr. Pandit, my lord. And your lordships also, the relevant question your lordship asked, what is the time gap in between the advertisement and the amendment? That
So we, Mr. Mohanty, we generally put relevant questions.
yes. Right. My lord, I don't say that it is irrelevant, my lord, but it may be relevant in certain context. It may be not be relevant for certain context, my lord.
But still you will have to answer even irrelevant questions.
So, my lord, I say that it is free for the government to prescribe an eligibility criteria which may exclude, but it's no more it is.
All right, another relevant or irrelevant question. So had the gate score been part of Rule 6, all right,
Then my situation would have been different, my lord. My lord, I will not question the government's competence to enact a rule prescribing eligibility, my lord.
all right.
No, that would be stretching it too far, my lord. And the settled position of law is probably the government is free. But that rule can be challenged in any other ground, but not on the ground of this. So I say that if you 6 and 7, their incost is consistent. But I am aware of the fact that the first effort of the court should be not to strike down something, but to give it a meaning, reading it together. That I am. But where each other is proposition is mutually destructive, then your lordship has to take a call,
Yes.
Then the second is, it is a matter of public employment. In the public employment in a welfare state, state is supposed to provide, but your lordship, the example I give, I can't afford a postgraduate exemption, but I am a graduate engineer. You prescribe a qualification that this service is available to it.
But before you make this submission, you will have to say that the gate examination is unaffordable.
And I am not intending to get exemption is also expensive, no? You have seen, my lord, your lordship sees the information brochure, my lord.
Yes.
Graduate introduction aptitude test in engineering is a national examination conducted jointly by the Indian Institute of Science, Bangalore, and the 7 Indian Institute of Technology at Bombay, Delhi, Guwahati, Kanpur, Kharagpur, Madras, and Roorkee on behalf of the National Coordination Board, Department of Higher Education, Minister. Qualifying in GATE examination is mandatory requirement for seeking admission and or financial assistance in master's program, direct doctoral program, doctoral program in relevant branches of arts and science in the institution supported by the MOE and government agencies, even some colleges and which admit students without MOE scholarship and the GATE qualification is mandatory. Further, many public sector have been using the GATE score in their recruitment process. The information in this brochure is mainly calculated as pre-exemption GATE. GATE is not an admission ensuring exemption. Qualifying in GATE exemption doesn't guarantee admission
No, but how
scholarship.
do you say, Mr. Mohanty, that it is unaffordable?
Then I am telling
See,
that.
and what you are reading from
Yes.
that also it appears that some of the public undersector provide this as the basis for recruitment.
Yes, yes. But there may not the eligibility criteria is prescribed as the GATE exemption.
That we have understood.
Ah.
According to you, GATE qualification, because it is mentioned as part of selection process, therefore it is incorrect. Had it been in Rule 6, the matter would have been different.
I am to fortify it, I am telling that it must give a level playing field to all candidates having degree in engineering.
How do you say that they don't have the level playing field? Because
No,
every
because
engineering-
because
every
if
engineering-
you are prescribing lot,
because
I am not debarred from applying, my lord. Your lordship will kindly visualize a scene, my lord. I am not debarred from applying to the post because I have the eligibility. But in effect, what happens? That even if I apply, I am only required to appear in the Viva test, which gives only 10 marks, my lord.
So you could have appeared.
So
in the exam.
effectively,
You could have appeared.
What I could have done, my lord, is not the question, my lord.
This is the question.
What is the practical thing, my lord, effect of it?
Practical, we are not dealing with the practical aspect. We are dealing with only legal
Sometimes
aspect.
the government could have also prescribed the GATE as the qualifying eligibility criteria. If from amongst the eligible candidates, you give a preferential marks to the but which the impact of totally excluding somebody is last time also I have cited it your lordship will see 209. The judgment of the Honorable High Court of Patna, now. Where they say that per se it is not, they are not against GATE exemption or anything, but they come to the conclusion that since the preference granted excludes the eligibility criteria person from consideration.
By Honorable Mr. Justice Kataria or?
Like Jyoti Saran and Partha Sat.
Yes.
These are right.
Yes. Quoted in?
Lord, that is in 209, my lord, annexure 11, my lord. I'm giving a copy of this. Lord, may I be permitted to place it, my lord? Lord, may I place it?
Yes.
In order to appreciate the fact, my lord, let me place it from the beginning. In each of the two writ petitions, the prayer is common and a challenge is made to the amendment in the behalf of the Ethnic Education Service Rules 2014 notified through notification number such and such, whereby table 2 of appendix 1 of the rules has been substituted to waive of the requirement of a written test for the purpose of evaluation of work knowledge and teaching skill, and which has given way to evaluation on the basis of percentile obtained by candidate in the graduate aptitude test in engineering examination. Consequently, the petitioner have also questioned the advertisement dated 7/3/2019 and 8/10/2019, copies of which are placed on record. Then, my lord, your lordship, your lordship.
Yes.
Then your lordship skips over the submissions, you know. Lord, 225, then running page 225.
No, but here, whether the advertisement was under challenge or the statutory provision was
Statute
under
and advertisement both.
rule, where is the, where is
My lord, the substitute. Lordship,
of the rule? Yes.
The entirety.
Right.
Lord, page 225, if your lordship, it skips over those facts and the submission.
Yes, sir.
Your lordship skips over. Lord, may I be permitted to place to page 225, my lord, the relevant portions only there. Lord, in the nature of the dispute, thus which transfers from the argument advanced by Mr. Singh, learned counsel appearing on behalf of the petitioner, as responded to by Mr. Advocate General, we do not find it necessary to delve into the issue of separation of powers, because in our opinion, such conflicts doesn't arise in the present case. It is now to be seen whether the amendment to Table 2 of Appendix 1 to the rules framed by the state of Bihar, by memo number 889 dated 10/4/2017 at Annexure 8, insofar as evaluation on work knowledge and teaching skill is concerned, would sustain the test of Article 14 and 16 of the Constitution of India, and or whether it strikes at the very root of the equality clause, equal opportunity and equal treatment to all in the matters of public employment. Then, my lord,
appointment of lecturers.
for the purpose, we are persuaded to take note of some of the relevant provisions of Service Rules 2014, which was framed for appointment to the post of teachers in Government Polytechnic, Government Women's Polytechnic Institute, while Rule 3 provides for the cadre structure and empowers the state government to frame service conditions. The regulatory provision for direct appointment is present in Rule 5 and which is provided in Appendix 1 accompanying the said rules. Since the present case relates to the appointment of lecturers and assistant professor in Government Polytechnic, Government Women's Polytechnic from the field of engineering, we would be making reference to the prescribed qualification and experience for such direct appointment as present in Table 1 of Appendix 1, which runs under post of lecturer in qualification, engineering technology, bachelor's degree in engineering technology in the relevant branch with first class or equivalent. If the candidate has a master's degree in engineering and technology, first class or equivalent is required at bachelor's or master's level. The weighted scheme as it originally existed in Table 2 of Appendix 1 insofar as field of engineering technology is concerned, provided as follows. A total weightage 100, academic record and research work evaluation of work knowledge, interview. 30, 50 and 20 million. Academic record and research work 30. Then without work knowledge and teaching skill through written test order 50 and 20 on the basis of the interview. A plain look at the qualification prescribed for such appointment at table 1 would confirm that the basic qualification for such appointment is a bachelor degree in engineering technology. Insofar as the weightage scheme is concerned, as against total weightage of 100 marks, 30 marks is earmarked for academic record research work. 50 marks is reserved for evaluation on work knowledge, teaching skill to be done through written test, and 20 marks is reserved for interview. Now, whereas weightage of 30 marks on academic record allows 15% of the marks obtained in BTech, 10 marks obtained in MTech, and 5 marks obtained in PhD. The evaluation on work knowledge and teaching skill was to be done through a written test for which the syllabus of GATE was prescribed. In other words, while the academic record and gave preferential marks to those having MTech and PhD qualification, insofar as the evaluation on work knowledge and teaching skill is concerned, each of the candidates has to go through a written test, thus providing equal opportunity to all candidates. The scheme reflected transparency and fairness in selection procedure. This weightage scheme at table 2 has been interfered with by the impugned amendment at Annexure 8, whereby now 50% marks is reserved for academic record research, where 30 marks is reserved for evaluation on work knowledge and teaching skill on the basis of marks obtained in GATE, and 20 million. Your Lordship, may I pause for a minute and draw your Lordship's kind attention to the fact that it is GATE exemption was there prescribed only in respect of 30 marks reserved for evaluation of work knowledge, my lord. Even then, my lord, I will read further, my lord, 20 marks for interview. There is absolutely no issue on rearrangement of weighted marks amongst the different categories. The problem which arises by virtue of this amendment is that in the process of amending the scheme of evaluation on work knowledge and teaching skill, the state has done away with the scheme of written test, and insofar as the candidate seeking appointment in the engineering and technology branch is concerned, they are now to be assessed on the basis of percentage obtained by the GATE in the examination, subject to a maximum of 30 marks. It is the contention of the petitioner that qualifying in GATE is a mandatory requirement for seeking admission in master's doctoral program in engineering, technology, architecture, and since the petitions are already having postgraduate qualifications, they are not required to appear at such exemption. According to Mr. Singh, while the petitioners are not required to pass GATE exemption because they are already postgraduate, this situation deprives them of the valuable 30 marks for being evaluated on their work knowledge teaching skill. We do agree with the issue canvassed and are completely at loss to appreciate the change in the procedure of evaluation of candidates on their work knowledge teaching skill. Because while the weightage scheme as it was originally framed allowed equal opportunity to all the candidates for being tested on their work knowledge teaching skill through a written test to be held on the pattern of GATE, the state by waiving such requirement has deprived candidates who are not even required to pass GATE exemption for being evaluated on their work knowledge and teaching skill, even if they do possess such experience. Even if the state under Article 309 has a right to frame rules in matters of public employment, every such rule has to withstand the test of arbitrariness and rationality, besides being transparent on the procedure. But the amendment substituting Table 2 of Appendix 2, memo number whereby it is decided to waive off the transparent evaluation of candidates on their work knowledge and teaching skill by way of written test, and to simply mark candidates on the basis of marks obtained in the GATE exemption, not only hits transparency, but also discriminate against such of the candidates who are already postgraduate and are not required to pass such GATE exemption. Much has been canvassed by Mr. Advocate General in reference to the rules as it was originally framed, that the written test shows prescribed for such evaluation had a syllabus of gate, and thus if the state has now allowed the candidates to be marked on the basis of passing such examination, not much change has happened on the procedure. But in our opinion, such stand is only taken for rejection because an evaluation of a personal attainment of a candidate, either on academics or work knowledge or teaching skill, has to possess a degree of equality for placing the candidates at equal level. And even if a better qualification with such requirement would be justifiable, as one can see in the case of academic record and research work, where while 25% mark is reserved for basic qualification of BTech, the candidate possessing postgraduate and PhD qualification are given additional marks. The process of evaluation of teaching skill, work knowledge on the basis of mark obtained in the GATE examination, how such of the candidates from such consideration who have either not passed the GATE examination.
We have read the judgments.
Well,
We have read.
231 is the relevant price. As you have observed, there can be a preferential category within a particular category. But a weighted scheme which deprives a candidate from consideration against a particular attribute in its entirety suffers from the vice of arbitrariness, besides being different, lacking of reasonableness. But then, your Lordship sees this matter was carried to the Honorable Apex Court.
That also we have seen.
That also your Lordship has seen. Then, my Lord.
So the only difference between the rule, the Bihar rule and the Odisha rule is.
But there are only 30% of marks. Here, 90% of the marks.
That was that in the weightage portion, this was incorporated.
Yes.
That for GATE, you will get this. For PhD, you will get this. For this, you will get this. And this is how the merit was to be.
Well,
the division bench was of the view that prescribing such huge number of marks for GATE qualification will amount to exclusion of candidates who have not participated in the GATE examination. This is the.
That's right, Mullah. Mullah, I was teaching that there it was only 30% of the marks. Here, you will find that 90% of the marks won. But then another two decisions, Mullah. But that is not exactly will fit into the facts of the case, except 2 lines, Mullah, of the Honorable Apex.
Is there any direct Supreme Court decision on this point? No.
And I have not examined the latest, but 2 months back, whatever I saw.
Okay.
But there the qualification was prescribed by the statute. But while recruiting it to the post, my lord, the junior assistants of the district judge, my lord, there they prescribed higher qualification. Then, my lord, that is not exactly touching the you'll see that very many decisions was cited in favor of that the employer has a right to prescribe a higher qualification to him. Well, only paragraph 16 of that judgment, your Lordship may kindly have a glance. No, one line. There the High Court sustained the.
Yeah, no. So that's it. But if you don't have the page numbers,
this is a screening test, Mullah, where higher qualification was.
Yes.
Mullah, you will see for the facts, Mullah. Paragraph 6 at page 706 of that printout. Has your lordship got it? May I place it? We may record at this stage that for the 17 post of junior assistant, 9,366 applications were received from the candidate who has the intermediate qualification. On the premise that it is a very large number for 17 posts, the discharge decided to shortlist the candidate. For this purpose, reliance was placed on circular such and such, which reads as under: the selection committee shall screen all the applications from the list A to C and shortlist the same, keeping in view that not more than 25 candidates will be considered for the vacancy. Voilà.
That is different.
No, that is why I told my lord, paragraph 16, your lordship will kindly have a glance, only one line. Has your lordship got it, my lord? Page 710. We fail to understand. Has your lordship got it?
Yes.
How a person who fulfills the eligibility conditions as per the recruitment rules can be excluded even from appearing in the qualifying written examination by fixing higher educational qualification benchmark. So, what in effect is that you have the eligibility, you must be given a chance to be considered, my lord.
Yes.
Then, my lord, I don't think I have to cite that decision about indirect discrimination. That judgment of Lieutenant Colonel Nitisa and others versus Union of India, my lord, where it is stated about that discrimination. That you will get only one paragraph.
Yes.
Only one paragraph.
Paragraph of this decision.
Huh? No.
The other case.
2021, I do not have a copy, my lord. Page, my lord. That is about the general principles of the indirect discrimination. My
All
lord,
right, give that decision.
where they say that there can be two types of discrimination. One is by intention. And if the intention is right from the beginning to exclude, then it is discriminatory. But if the impact even is, the intention is not that, but the impact is effectively keeping somebody out, that is an amount of discrimination. That is AR Supreme Court 2021 15 SCC 125.
Again, please.
Huh?
The citation.
It is 2021 15 SCC 125, equivalent to AR 2021 Supreme Court 1797. I have got the AIR that is relevant for paragraphs are 66 to 70.
We'll,
Should I place it?
no, not yet, we'll see.
So about those latest decision about the gate, because this is a new thing coming up. I have to check up whether under Article 16, Supreme Court has given any judgment in respect of the public employment.
That's all.
That's all.
I mean, sorry. I am in WPC 8166 of 2024, Satyabrata Sahu, in that case.
WPC
8166 of 2024. But I was hearing Mr. Mahanti also recently, and your lordship's query also about the. But certain background is there, therefore I prepared a date chart. So far this case is concerned, though the virus is challenged, but certain background is necessary. And your lordship also made the query, that query can be also answered on the basis of this. And the original rule is 29/12/2012. The Orissa Engineering Service Method of Recruitment Condition of Service 2012 was notified. Rule 7.3 of the said rule provided for selection on the basis of career evaluation, objective type written test, and Viva's test. As Rule 7.4, Commissioner was required to prepare a select list of candidates in order of merit on the basis of the marks secured in career evaluation, objective type, written test, and Viva's. That is Annexure 1 at page 41 in my brief. Then after 2012 on 5/8/2019, I have given to your lordships that Patna judgment, that which my senior friend Mr. Mahanti has already placed, was filed before the Honorable Patna High Court, challenging the amendment in Bihar Polytechnic Rule 2014, wherein it was incorporated by way of amendment that evaluation of work knowledge and teaching skill was to be done on the basis of marks obtained in GATE. The said amendment was struck down by the Honorable Patna High Court on the ground that the same was discriminatory. That is, I have given also that copy of the judgment. Then 28/1/2021, and before this 28/1/2021, there was an amendment which Mr. Mahathir has placed in 2014. There is a slight amendment so far as the eligibility and also the manner in which the OPSC will conduct the examination, and the weightage has to be given. But 21, for the first time, this 28/1/2021, the amendment was incorporated. The previous amendment, which was the subject matter of challenge in the earlier division bench. The Orissa Engineering Service Method of Recruitment Condition of Service 2012 was amended. Our Rule 7.3 and 4, which provided for method of selection on the basis of marks awarded for career marking, written test, and Viva's test, were substituted with quotation, the highest GATE score obtained in the last 3 years preceding the advertisement. That was the amendment made earlier in 2021. On 18/3/2023, on the basis of that amendment, an advertisement number 20 of 2022-23 was issued by OPSC for recruitment to the post of Assistant Executive Engineer, same post, civil, and Assistant Executive Engineer Mechanical in Group A of Orissa Engineering Service under the Water Resource Department. Same post. Now they have been advertised. 1/5/2023, various writ applications were filed. WPC number 15738 of 2022, which was a lead case, and batch of the writ application were filed challenging the constitutionality of the amendment rule of 2021 and the advertisement dated 18/3/2023. This Honorable Court, by judgment dated 1/5/2023, was pleased to declare and strike down 2021 amendment rule, and consequently the advertisement dated and sorry. And sorry. Next. Serial number 5 of my date of events.
Yeah.
WPC number 15738 of 2022 and batch, writ petition were filed challenging the constitutionality of the Amendment Rule 2021 and the advertisement dated 18/3/2023. This Honorable Court, by judgment dated 1/5/2023, was pleased to declare and strike down the 2021 Amendment Rule, and consequently, the advertisement dated 18/3/2023 published by OPSC was quashed. This is on 1/5/2023, Lordship delivered the judgment. On 30/8/2023, Lordship, mark it here. Online application started for applying for the GATE 2024 exemption. Pause for a moment, my lord. Right from 2012 till this 2021 rule came into, amended rule came into force, the concept of GATE was not incorporated in the 2012 rules. For the first time, it was incorporated in 2021, and it was challenged before your lordship in 2023, and your lordship delivered the judgment on 1/5/2023. Yes, and they went to the Supreme Court, and Supreme Court also that I'll come. I also
One of the grounds for setting, one was that PSC, that consultation was not there. And secondly,
your lordship, I am coming to that.
secondly,
Lordship
that 3 years.
Yes, I am coming to the lordship judgment, because that point I think I'll bring to my lord's Chief Justice notice. 30/8/2023, online application started for applying of GATE 2024 examination. After the rule was declared to ultra vires on 38, that means judgment was delivered in the month 1st May. Then on 38/2023, online application was started for applying GATE. On 29/9/2023, last date of making application for GATE. Then on 39/2023, the Orissa Engineering Service Method of Recruitment and Condition of Service Amendment Rule 2023 notified by notification number dated 26/9/23 was published in the official gazette. This is the now subject matter of challenge. Then you also kindly see on 39, the rule came into force. On 28/12/2023, the impugned advertisement, that means consequent to this amendment, impugned amendment, this advertisement number 19 of 2024 was published by OPSC for recruitment to the post of Assistant Executive Engineer Civil and Assistant Executive Mechanical in Group A Orissa Engineering Service under Water Resources Department at Annexure 8 at page 168. That means within 3 months, the advertisement was made. And you also see the next date is very important. 12/1/2024, the process of making online application was supposed to commence pursuant to the above advertisement. Then on 12/1/2024, the second corrigendum was issued to the above advertisement, rescheduling the date of making online application. Then on 19/1/2024, in view of the second corrigendum, the process of making online application started. The next date is 19/1/2024. Third corrigendum to the advertisement was issued by the OPSC, that is on 19/1/2024, stating therein a candidate must have valid GATE score on the subject GATE paper of civil engineering and mechanical engineering. That is annexure 14 at page 235. Then February 2024, let's mark it. The GATE examination was held only after the process of started pursuant to that advertisement. And the February 2024, after your lordship delivered the judgment in the earlier case, the GATE examination was held only in the month of February 2024. By that time, by virtue of the third corrigendum, the process was already completed. Then to 19/2/2024, last date fixed for making an online application. Then March 2024, GATE 24 result was published. That is after the last date fixed for making application pursuant to the advertisement dated 28/12/2023. Then 7/3/2024, several writ applications were filed before this honorable court. Lead case is WPC 596 of 2024 and connected cases challenging the advertisement dated 28/12/2023. And this honorable court, after hearing the counsel for the petitioner, state and interveners, was pleased to direct the opposite parties to proceed with the selection process pursuant to the advertisement dated 28/12/2023, but not to publish the final result of the recruitment test without leave of the court. This is the background. Now at this juncture, the lordship, one paragraph of the earlier judgment, I take your lordship, page 161 of my brief. Page 161 of my brief. I am conscious that your lordship is hearing the various matters, but these are all in connection with the virus, my duty is to bring to your lordship's notice. Page 161. The earlier judgment where my lord said that consultation of OPSC has not been made in terms of 323.3. That is one part. The other part, what your lordship have said at page 161, I'm just doing. Sorry. That is 9 and do paragraph to go to the yes, sir.
Which sub item?
I'm just for a moment. Just you'll also kindly come to page 153. I'm sorry, 153. 153.
Your writ application?
The judgment of your lordship.
No, your writ
My
application.
writ application. Yes, the page that you cannot tally with Mr. Mahanti's. That's why just kindly have a. I was thinking that I will take borrow the brief of Mr. Mahanti so that it will be convenient to lordships. But sorry, I couldn't.
All right.
Page 153, para 27. An additional ground for quashing the impugned advertisement is
You are
that
asking which page?
page 153. Let's get it.
Yes.
Yes, sir.
Yes.
Para 27. An
Yes.
additional ground for quashing of the impugned advertisement is that candidates have not been provided enough time, public opportunity to appear in the gate examination. Thrice before publication of the advertisement dated 18/3/2023, the highest valid score for the preceding 3 years from the date of advertisement has been provided in the method of selection in the advertisement, thereby depriving candidates who had not appeared for the gate examination in the year 2021, this process for which admittedly began in 2020, before the publication of the Amendment Rule 2021, which were published on 28/1/2021, while the advertisement has been published on 18/3/2023 of a level playing field, placing them at a disadvantageous position as compared to candidates who were able to appear in the gate examination thrice before publication of the impugned advertisement, and thereby discriminating against them. Rule 41142 of the Orissa Engineering Service Recruitment Rules, Amendment Rule, amending 72 and 73 of the Orissa Engineering Service are hereby struck down. That your lordship have already seen. But so far paragraph 27 is concerned, here, last year, 3 preceding year, that the your lordship has already followed. The other, now your lordship or my senior friend was placing that partner judgment. I need not require to place it again. But your lordship, I was marking that your lordship have gone through that entire judgment, including the order passed by the Honorable Supreme Court. But so far as this court is concerned, in the earlier judgment, what is the view of the division bench of this Honorable Court, so far as the partner judgment is concerned? Your lordship may kindly come to page 161. So far as Article 323, that I will place later on. But so far as partner judgment is concerned, let's come to page 161, paragraph 42. In Ramon Pandey's versus State of Bihar, the judgment dated so-and-so delivered in civil writ jurisdiction so-and-so, the Patna High Court was examining the virus of the amendment of Bihar Polytechnic Education Service 2014, by which the requirement of written test and evaluation in the teaching skill was deleted, and it was provided that by evaluation of percentile secured by the candidate in the graduate aptitude test GATE in engineering examination, selection will be made. The said amendment was challenged in a few writ applications. While deciding the controversy, the Patna High Court has observed that though there is no apparent breach of Article 14 of the Constitution, but for introduction of the GATE selection method, the candidate having higher qualification or experience will not get due weightage during the viva's test. It has been observed thereafter that there cannot be a preferential category within a particular category, but a scheme which deprives the candidate from consideration against a particular attributes in its entirety suffers from vice of arbitrariness, besides being discriminatory and lacking reasonableness. In fact, the change that has been brought about has created a class within a class of candidate. In so far as the evaluation of the work knowledge is concerned, the object is entirely missing. Then para 43. It has been observed in Rammohan Pandey's case, Supra, quotation. Even if the state under Article 309 has a right to frame rule in the matter of public employment, every such rule has to withstand the test of arbitrariness and rationality, besides being transparent on the procedure. But the amendment substituting Table 2 of Appendix 1, thought memo number so-and-so dated 10/4/2017, whereby it is decided to waive of the transparent evaluation of candidates on their work knowledge, public teaching, skill by way of a written test, and to simply mark candidates on the basis of the mark obtained in the GATE examination. Not only is transparency, but also discriminates against such of the candidates who are already postgraduates and are not required to pass such GATE examination. This is quoted from the judgment in Patna. We are also confronted with the similar circumstances. Finally, the Patna court held the said amendment as discriminatory, and hence the same was set aside in its entirety. In the said judgment, Patna High Court, some additional features were also considered for interference. Those who are not very material in the present context. But what the Patna High Court has significantly observed is this. Since we have struck down the amendment to Table 2, Appendix 1 of Rule Quotation in its entirety, the evaluation obviously is to be carried out as per the scheme originally framed at present in Table 2 of Appendix 1, which accompanies the Service Rule 2014. The Service Rule 2014, as referred to in Patna High Court judgment, is unamended rules. When the amendment is struck down and the earlier rule are not interfered with, the earlier rule swing back to the operation, to its operation. I would further like to put on record that the said decision of the Patna High Court was challenged in specially petition number so-and-so, but the specially petition was dismissed by the Apex Court by their order dated so-and-so. A responsible executive cannot cite the status of a constitutional institution like so-and-so, so-and-so. But in fact, I have prepared on my own way, but since your Lordship put some question to Mr. Mohanty, I was talking to Mr. Palin, we must answer your Lordship's query first with reference to the judgment of the Supreme Court. Can your Lordship give them some time so that at least I will have a study for the research on the matter, then I will address. Because unless I point out your Lordship's query and I must answer to that, then I will go to the other question.
Which query?
The question which your Lordship put, that section, as Mr. Mohanty argued, Rule 6 of 2012 says the eligibility criteria. That means graduate is the eligibility criteria. And so far Rule 7.2 is concerned, it clearly speaks that as per the eligibility criteria, OPSC has to forward and to send the requisition. But so far as 7.3 is concerned, now that has been deleted. The written test, objective type questions, bias, that has been deleted, and the manner of weightage of mark which has given to the OPSC, that has also been deleted. At this juncture, I will place so far the OPSC's power is concerned, Article 320. Article 320, which was also considered in the earlier judgment, so far as the consultation is concerned. Consultation, Article 323, subclause 3. But here I am addressing on Article 321. You'll also look to 321. Function of Public Service Commission. One, it shall the duty of the Union and the State Public Service Commission to conduct examination. Sorry.
Yes, sir.
It shall the duty of the Union and the State Public Service Commission to conduct examination for appointment to the service of the Union and service of the state respectively. Well, what I'm trying to subject your Lordship's acceptance, now this examination part in respect of a civil post, it's an exclusive domain under the constitutional mandate to the Orissa Public Service Commission. What they have done now.
What is the post? What is the post?
Well, the present post is assistant executive engineer. That is a civil post. That is engineer. Yes, sir. That is admittedly a civil post. State government. All government, it is state government.
For all posts, the UPSC is not constitutionally bound to hold exam.
And the service,
Those are exempted by the president.
those are exempted. That is a provision of provision.
those which are in affairs of the services, which relate to affairs of the state or the union, as the case may be.
Yes.
There must be some provision.
There is a provision of proviso that will
It does
become,
not apply to every service.
that is to conduct examination for appointment to the services of the state.
No, there is a provision, there must be a provision that the Union Public Service, Public Service Commission is required to be consulted.
That is
Literally required to be consulted.
323, that is the 323.
323.
Yes, the Union Public Service Commission or the State Public Service Commission, as the case may be, shall be consulted A, on all matter relating to method of recruitment to civil services and for
So
civil.
you are reading Article 23,
320 subclause 3.
320 subclause.
Yes,
3,
yes, sir, sorry.
That must be the provision.
320 subclause 3. Sorry.
Yes.
The Union Public Service Commission or the State Public Service Commission, as the case may be, shall be consulted A, on all matters relating to method of recruitment to civil service and for civil post. B, on the principle to be followed in making appointment to civil services and posts in making promotion and transfer from one service to another, and on the suitability of the candidate for such appointment, promotion or transfer. C, on all disciplinary matter affecting a person serving under the Government of India and Government of State of Orissa in a civil capacity, including memorials or petitions relating to such matter. D, on any claim by or in respect of a person who is serving or has served under the Government of India or the Government of a state or under the Crown of in India or under the Government of India state in a civil capacity, that any cost incurred by him in defending legal proceeding instituted against him in respect of the act done or purported to be done in execution of duty should be paid out of the Consolidated Fund of India, or as the case may be, out of the Consolidated Fund of the state. In the earlier judgment, this 320 subclause 3 was the under consideration because consultation was not there. Now I am placing 321. The examination has to be conducted by the OPSC. That what your lordship have found in the earlier judgment finding, I'll place that. So far 320 is concerned.
Yes.
Yes. Now at this juncture, lordship, come again look to 321. It shall be the duty of the Union and the State Public Service Commission to conduct examinations for appointments to the service of Union and the service of the state respectively. Then you also kindly look the judgment which I was just placing before ourselves.
Yes.
That is at page 157. On 57 of my brief, the judgment which I was citing to lordship in the other context in Patna High Court judgment. Now I am referring to this article 320. What is your lordship's finding? Lordship, kindly come to page 157. Para 32. Honorable Rathu has elaborately dwelled upon the fallout of the said change, but when I want to lay the emphasis is whether by incorporating above change as reproduced, the constitutional role of the Public Service Commission has been slighted or completely excluded. For the purpose, let us revisit Article 320. The text of Article 320 has been reproduced by Honorable Justice Rathu. 33. The unequivocal terms Article 320 has laid down the function of the Public Service Commission. The Public Service Commission for the Union or for the state has a distinct status under the Constitution apart from the government of the Union or the state and cannot be identified with such government. Then 34. The fundamental purpose of constituting the Public Service Commission has been discerned of the Article 320 of the Constitution. The Public Service Commission is to conduct examination to the service of the Union and service of the state. The Public Service Commission, as well as as well be consulted in all matter relating to method of recruitment, civil service and for civil post. In view of that provisions, the opposite party number 1 and 2 had commenced the consultation in respect of, let's skip over because that is regarding 323 regarding consultation. Let's skip over. Then para 35. The said amendment has been adopted in an arbitrary manner, but such amendment function of the Public Service Commission has been reduced to that of a ministerial job. The Odisha Public Service Commission has given their opinion by not accepting the proposed amendment in toto. Then para 36. In my considered opinion, the said amendment has completely excluded the function of the Odisha Public Service Commission as enshrined in Article 3 and 20 of the Constitutions. Para 37. There are 37 that Article 23C has been referred to. Let's skip over. Kindly come to para 38. Rule 7 of the Odisha Education Service Rule, Odisha OES rules, unamended part, still provide that selection to be made by the Public Service Commission. But no role has been assigned to the Odisha with the Public Service Commission by the amendment that has been implanted by deleting the original subclause 3 and subclause 4 of 7 of the OES rules. It is complete exclusion of consultation with the Public Service Commission. This is para 39. This is a unique example of applying the power of subordinate legislation against the constitutional authorities. Then you also kindly come to para 40.
Why don't you continue reading?
Yes. The opposite party number 1 and 2 were under obligation to give the consideration of the opinion of the Odisha Police of the Public Service Commission while adopting the amendment. As shown from the records that the cabinet was misinformed about the opinion of the Public Service Commission, and as such, there is no consultation in the eye of law. Merely sending for opinion is not enough to draw an inference that consultation is done. Such inference can only be drawn when the opinion of Public Service Commission is duly considered, either by way of accepting or by way of discarding with adequate reasons. Even the opposite parties 1 and 2 themselves have stated that any opinion of the Public Service Commission should not be ignored or discarded casually. Para 40. In the case in hand, there has been no consultation at all. The consultation with the Public Service Commission in the recruitment of civil posts.
Sir, we are interrupting.
Sir.
Is there any notification in Odisha exempting services from the scope of this the requirement under chapter 2 under the public service?
I have to check up. I have to check up.
But where is Mr. Mahanti? Who's appearing for the commission?
I'm there for the commission.
Yes.
There must be, in fact, see. It relates to the function of the commission for the purpose of recruitment. Constitutional function mandatory is confined to appointment to such posts which relate to the affairs of the union or the state. Not like the commission is not under obligation to recruit constables.
Yes.
Which post is also a civil post under the state.
There is, I think there is a circular which has been also considered by a division bench of this court.
So the circular must be there.
Yes.
Circular must be
excluding,
there.
yes.
Excluding.
Yes.
So excluding those posts.
In terms of,
all
yes,
posts,
in exercise, yes.
all
No, I have to
posts,
verify. I'll have to find out.
I'll just.
Yes.
And then we may need to examine whether this engineering service.
Yes.
Service.
Included or excluded? That
It may not be excluded, whether the service can be said to be in this thing in relation to affairs of the
state or union.
The union.
Right.
So the idea is that all the gazetted posts, they are considered to be in relation to the affairs of the state or the union.
Right.
So, all right.
That's
That's a question not very relevant for this. I was just trying to.
Yes, I'll try. We'll try also. All of us will try also to get it.
In fact,
we'll check out.
In fact, See, there is a question. We will decide this is limited scope,
Yes.
but in some of the, like in Bihar, they have constituted technical commission, state technical commission. And that state technical commission makes recommendations for appointments to the post of engineers and doctors to draw a parallel.
Right.
That what is the meaning of examination?
Right.
See,
Because you're going to root of the matter, yes.
see the difference between, there is difference between selection and examination. That is going to be different. All right. So if it is confined to selection, then the OPSC can say that, all right, you hold the examination, we will select on the basis of your examination.
Right.
All right. So whether what they are doing can be considered to be examination or not.
Right.
Or whether it is constitutional obligation on the
Yes.
OPSC
Mandate, yes.
to
Hold the examination.
The examination.
Right.
Examination, again, this expression you will have to, because you are harping on the constitutional provision, then it may be mandatory for this post that and if this post comes under that provision of the chapter of the Constitution, then it may be mandatory for the OPSC to hold a examination. Examination may be, again, they may say what we are doing is examination. You may say no, examination means either written examination or oral examination. These are the issues which we shall consider. So
you also keep it so that we can proceed.
We have to examine it.
Monday. So
Monday.
I would like you to address.
Yes, sir. Yes.
And that is very crucial.
Yes.
That the commission cannot abdicate its function of holding examination.
Yes, sir.
Conferred under the Constitution.
That is exactly
on gate.
Yes.
All right.
Yes.
That is exactly.
So
Exactly.
this question may emerge.
Yes, sir. Yes.
And about that, in terms of the state,
Judgment
they have 320 every place.
So constitutional. So Monday I have
I
tendency to forget the fact.
Monday.
And the law also.
Saturday, Sunday, Saturday, Sunday.
We'll see.
Monday or also keep it to Tuesday.
Monday. Matters of further. It's a very important.
Monday, your lordship is keeping it at 2 p.m.
No.
In the beginning. Okay.
But I have filed a writ appeal against the order of the Honorable Single Judge, because now the Single Judge has passed an order contrary to the statute. My humble submission would be, at this stage when statute is clear and unambiguous, the court should not add or delete a word in the statute, and the statute has to be respected.
You are appealing in this case.
No, yes, brother. I filed a writ appeal against the interim order passed by the Single Judge not to declare the result, because we are eligible, we have passed the gate, and we are supposed to be. We have also completed the interview.
Just Mr. Mishra, so in effect, you are opposing them.
Yes.
So you can address on that.
It's a larger issue.
I've also filed an intervention application in the
It's a larger issue to be decided once we hold that if that term examination means examination, oral and written both.
I understand your lordship's point, but
OPSC will have to hold examination.
It's a constitutional mallard's mandate.
No,
a mandate flowing from the
my
constitution.
contention is the rule is still in force, not declared ultra vires by this honorable court. Therefore, the Single Judge should not
have to establish
add or delete a word in the statute.
That this post is covered by that, and that is not excluded by.
Conversely,
what is that? I'm forgetting the name.
And the proviso is not excluded by the proviso to 3. 20 subclause 3 is not proviso to.
Called exemption notification or something. Some notifications are issued. You can find that in.
But there is a provision of exemption which was the subject matter of dispute in one case. I was arguing that I'll find out and I'll give
You can find that in the board miscellaneous rules or
It
something.
reads this way, provided that the president as respects the All India services and also in respects other services and posts in connection with the affairs of the union, and the governor as respects other services and posts in connection with the affairs of the state, may make regulations specifying the matters in which generally or in particular any class or in any particular circumstance it shall not be necessary for the Public Service Commission to be consulted.
So this has been notified excluding class 3.
Yes.
So this is,
I
there is
understand
there is a
what-
requirement of consultation.
Not to be notified in the official gazette that these posts are not required to be consulted in terms of Article 3.
The very fact that they have consulted.
No, so far Mr. Mishra's case is concerned, he had challenged the interim order passed by the Honorable Single Judge, where the advertisement was the subject matter of challenge on the ground that so far as the gate examination is concerned, in the earlier judgment, it was said that you must give some breathing space.
All right,
That is
we can hear the larger issue.
Larger issue, not speaking of the larger issue.
Grateful.
Stress admission item number 3.
Item 3 is Mr. Mahapatra's sir.
Item number 4.
Please.
Whereas item number 4 is concerned, my lord, on behalf of senior counsel Mr. J.K. Roth, my lord, he has requested me to make a mention with the lordship. He wants to be accommodated for today. And for lordship, fix it to any other day.
Item number 5. Item 5. Item number 5.
They think that the case would collapse and then this should be adjourned. देखो जी बोल रहे
My lord, item number 5 can leave adjourned. Item number 5 on behalf of Mr. P. Bose can adjourn the item number 5.
What do you want? Adjournment.
6 adjournment on behalf of Mr. Bose. Yes, sir.
The caveator also is nowhere in sight.
4 weeks.
Item number 6.
Lordship, can you pass over in
What?
Lordship, can you pass over, Lordship?
So the respondent.
I am for the appellant. State for the appellant.
Delay has been condoned.
Delay, your lordship have said that the limitation will be considered at the stage of admission.
All right, as requested on behalf of the appellant, this matter on Monday.
Oblige, Lordship.
Item number 7.
Item number 7, my lord, I am for the respondent. I am for the respondent, your lordship, on the last occasion directed to serve a copy of the writ appeal. They have just now served the copy. It may be given.
It is stated by learned counsel representing the contesting respondent that a copy of the writ appeal has been served upon him just now.
He is asking whether similar, your lordship has
one judgment is reserved in respect of the same matter that during pendency of criminal case, the department of whether this is that matter. He is asking whether similar, my lord has a reserved one matter. Day before yesterday, one matter your lordship has happened.
I'll just go through, my lord. Today I have got the writ appeal copy. Also, your lordship, sir, that matter I will also go.
This is not for 1 week, 2 weeks.
My lord.
Let it not.
What is the case number?
The writ appeal number,
The other one.
I'll give just.
Item number 8.
Mr. Lenko was
This matter was there yesterday. Your lordship have seen it and thereafter take your lordship's leave, my lord, for examining your lordship's judgment. Your lordship have already dismissed a similar writ appeal arising out of the very same common judgment passed by the learned single judge.
He wanted time to go through.
But in fact, the same para 5 is there. Some other writ appeal is also pending regarding the same. But if, that is the entire case. I've taken instruction, let me tell you. My learned senior, Mr. Mishra, was supposed to argue he's on his legs.
No, there's nothing.
What will he argue?
Only thing is, some other writ.
I'm sorry, extremely sorry, my lord.
So it is squarely covered, sir.
Yes, there's a judgment of division bench on which Chief Justice have delivered. And I'm lost at sea actually to argue the point after this judgment. In fact, with due respect, my lord, all those cases should have been tried together so that the counsels who wants to raise some.
Very difficult. If this is accepted, then first of all, will have to notify that this is the case where
Once it has been decided, it's very difficult to get over it.
Yes.
Once it is decided.
No, and see, the case has been decided on facts. On facts, on the ground that he did not have the original certificate in his possession. And this is the case in all other matters. They don't have the certificates with them and they have been found to be fabricated.
But the point of law here actually I wanted to canvass actually, which is subject to your lordship's appreciation. But that regulation 123 that this stand as a bar for applying. But more education doesn't prevent a person to make an application for a particular faculty. Because education is a factor which a person conceives and acquires throughout the life.
Difficult.
But here actually,
if you rely on a document which has been found to be fabricated, then you don't have any right to contest.
No, the document is not force. With due respect, document is not. He has appeared examination, he has passed. He has filed an affidavit that I have lost the original certificate, a duplicate certificate was obtained, and he made an application. That is exactly the point. But he has not committed fraud on education. No, his degree and educational qualification, everything remains intact. Only thing is, he got the certificate to apply for admission. That was he obtained by making an affidavit.
This is, according to you, your case is not covered by this decision because it is specifically mentioned that in this case, they were found to be fraudulently obtained.
No, that's not correct. Degree has not been fraudulently obtained. Degree is genuine, absolutely genuine, and certificate is genuine. He has got a more qualification. The regulation can stand as a bar to prevent somebody for a particular job. But what is the
finding in your case?
My case is exactly the same thing actually. If your lordship, what I argued for lordship, that regulation 1 to 3.
No. What is the finding on your certificate?
My case.
In your case, what is the finding?
Finding is that though I am eligible, but I obtained a certificate, higher degree, vocational course by obtaining a certificate by not disclosing the correct fact.
That is fraudulently.
But that this certificate was there.
Certificate may be there.
That is the only distinguishing feature, in fact.
The appellant has questioned.
If your lordship looks at paragraph 8.2 of my application, my lord, page 86. If your lordship kindly have a, with due permission of your lordship, my lord. Since the petitioner, after passing the HS examination, my lord, got 8.2, my lord.
Yes, but all those facts were there before the learned single judge, and same order has been
Yes,
appealed.
yes, yes. So that is.
The petitioner has put to challenge an order dated 21/2/2024 passed in WPC number 18225 of 2023 in the present inter-court appeal. So, a division bench of this court by an order dated 22/4/2024 passed in WA number 412 of 2024 has upheld the said decision of the learned single judge. So stop. Briefly narrated, the controversy relates to recruitment to the post of livestock inspector pursuant to an advertisement issued by the district chief veterinary officer, Jagat Singhpur district. Stop. The appellant was one appellant.
Yes.
The appellant was shortlisted. After following the recruitment process, stop, based on certain allegations, the certificates on which the appellant had relied upon for his selection were found to have been fraudulently obtained. Stop. After having taken into account the finding recorded by the learned single judge, this court in case of Rajkishore Barik and another bracketed Supra, WA number so concluded that the appellants of the said case did not have in their possession the original documents in support of their qualification. Stop. In the present case also, the appellant does not have the original certificates in his possession. Stop. In such view of the matter, we find no reason to take a different view than what has been taken in case of so and so Barik. Stop. This appeal is accordingly dismissed.
Because there is a difference.
No.
One is you have not pursued the course, but you produced the certificate. The other is because you had completed your HSC, you could not have pursued the course, but you pursued the course and got the certificate for which that you are not entitled to utilize the same.
Yes.
So that is the case.
Yes, that is the case. Exactly the
They
same
have
case.
pursued.
Exactly the same case.
No, you are the
We'll explain that, but same thing. You could not have acquired that qualification.
But fraud is not for acquiring qualification.
Exactly.
Fraud is here that my original certificate was filed before the HSC authority while doing that other course. So he said that my
It is not a case of fabrication according to you. It is a case of
Suppression.
original was lost. Therefore, I tried to file a false affidavit to get the duplicate. Yes, the degree is not fraudulent. The certificate.
You
is not-
have the degree, but you were not entitled to pursue that degree because you already had a HSC certificate.
So they are not rejecting on that ground.
Yes.
What they are rejecting is that one original certificate, HS certificate. I have prosecuted one study.
+2.
Then I wanted to prosecute the vocational course. Since the original was not with me, I applied for another copy, duplicate, by filing a false affidavit that I have lost the original. Give me another copy.
That means you had not passed HSC.
Well,
Yes.
they after getting
Yes.
passed in HSC, utilizing the certificate, they got themselves admitted into +2 course under the very same council. They passed the CHSE examination from +2 council.
HSC, sorry.
And by the misrepresenting the fact that they have not utilized the school leaving certificate issued in their favor from after passing the HSC certificate, they again ask for an duplicate certificate
copy
by virtue of an affidavit. And that culminated, that certificate, duplicate certificate issued in their favor, culminated into an admission by suppressing the fact that already passed +2 examination, which they could not have done under the regulation 123, which has been recorded by the honorable signature.
That is not fraud. Fraud is filing a false affidavit.
Obtaining certificate fraudulently. Like fraudulently has wider connotation in the sense that if you do something contrary to what is provided, in misrepresentation.
Yes.
By misrepresentation, if you do something that amounts to.
Only thing is, your lordship indicated by obtaining certificate by fraud, it's not certificate.
We will clarify what done will.
Certificate is not fraudulent.
Item number 10.
Wait, please, your lordship. My lord, item 10 is that nursing matter, which is that your lordship has passed an order in WPC number 16382 by 2024. That is item number 12 today.
My lord, in this case, my lord gave a direction to intimate the university for consideration of the SC/ST category, that percentile matter. We have intimated and both the petition of the petitioners councils. We have also referred. But now they have come with on this case.
Your lordship said SC/ST, OBC as well as the
No, my
other
lord,
categories.
I
They have only given to SC/ST.
My lord, that OBC, I will give a counter to that because it is there, it is in the INC's guideline, it has been said. I will read it out, my lord.
CST.
Let them serve the copy
Rule,
of
your
the
lordship said
ANC.
quoted also in the order. Your
Order is
lordship
my
will say
lord.
item 12.
Reservation of seats for admission in nursing colleges for SC/ST, OBC, EWSC, PH. Admission under the reserved quota shall be subject to reservation policy and eligibility criteria for SC/ST, OBC, EWS prescribed by the central government, state government, union territories as applicable to the college concerned. So here in state of Odisha, my lord, in all the technical and medical colleges courses, we have but only SC/ST, green card and physical handicap. Nowhere we are given to OBC or SCBC, my lord. That's why we are given a direction that SC/ST candidates should be taken into consideration.
That's why you given a direction?
That
We have
only
given the SC/ST candidates, their cases should be considered. Our prospectus also speaks about SC/SC, physical handicap and green card.
Yes, what is your case?
My lord,
My lord, we have only got SC, ST, green card and physical handicap reservations in education matters. So we have not given to OBC or EWS. That's why our prospectus also is also for SC, ST, green card and
Prospectus, you have admitted that there is some mistake
yes,
in your prospectus.
yes, ma'am.
Now you are allowing.
Yes.
Why only SC, ST? Why not others?
My lord, I have asked for instruction after getting this IA yesterday. So let it come. Next week, I will give the complete with data.
So when is the examination?
no, my lord, they cannot in any case appear. They will appear in the supplementary because the exam has already started. So they can give in supplementary.
My lord, I am for the health university, my lord. And the students, they have not yet registered with the university.
So it's only after the approval it can be
They
done.
require registration. And after registration, they will apply for, they fill up the form and it
All
will
right,
come.
let them be clear first.
Yes, madam.
May I?
OBC,
may I-
OBC,
may I-
Writ
may I-
petition's copy may be supplied to me.
Which copy?
Writ petition.
We will do that.
They are your friends.
Yeah.
We'll do that.
May I make
In the
a
course
small
of the
prayer,
day,
my lord?
we'll give it to.
May I make a small prayer, my lord? The notification they have made, today is the last date fixed to 5:30 PM. May I pray, my lord, that only one OBC candidate in both the cases left. Let the OBC candidate apply today by the cutoff time. Let them thereafter, your lordship, subject to your lordship's consideration and they are.
No, appear in the supplementary examination. What is
Yes,
it?
But today is the last date fixed for application.
Admit card is required, fill up the,
Yes.
fill up form and admit card, there is the basic need for the, to attend and.
No, that is not my point. Your lordship may kindly see, ticket again.
They cannot. without-
The difficulty is that, your lordship, to DMET, today is the last date fixed. That is annexed 14 I have annexed, your lordship may kindly.
Last date fixed for what?
To apply to DMET to get the registration, your lordship. But examination will appear later on. There is no difficulty. Your lordship may kindly see Annex 14 notification. DMET has fixed it to 31/7/2024 by 5:30 PM.
students for SC, SC and OBC category as he is placing my lord, as per the INC guideline. So we have given a notice on 25th because that within the 31st of
That is only for SC,
July.
ST.
That is
OBC
SC,
not
ST.
mentioned.
Yes. No,
So
SC,
they can
OBC have not
prayer
Take
is
the instruction, that
My
can be
prayer is
extended
that
to OBC also.
because the last date is fixed today, let the OBC candidate apply only to DMET. They may consider as per your lordship's order, but let the OBC candidate be permitted to apply today because the cutoff date is by 5:30 PM today. That I have submitted, your lordship.
My lord, let them apply. We have no objection because you have to give the information to the council that
For
who are the
everything
students
you
about.
want this court to pass an order. We will do that,
Yes, madam.
but that will be very expensive for you. What is this? You are saying for SC, ST, we had to pass an order. For OBC, you want us to pass an order. For EWS, you want to pass an order. So are we running your DMET?
No, my lord.
So
Sorry.
if we are made to run your DMET, then what we are observing that will be a very costly affair for you. It's very expensive for
No, my lord,
DMET.
I will tell them
You
that they
want to bear that expense.
Yes.
Who is heading DMET? Who
Doctor-
heads DMET?
Doctor, my lord. Professor SK
Doctor,
Manas.
the entire DMET should be reconstituted. What irresponsible act is this?
I will see that it's correct date is given. OBC, they will consider.
So tell us that too. Do you tell us what have you done at 2 PM?
Yes.
Item number 11.
Item number 11.
In this case, my lord, on 23rd July, your lordship directed to file an counter affidavit. Mining officer telephoned me, my lord, to grant some time, my lord. He is preparing, my lord. Within a week, you will file.
As requested on behalf of the estate, 1 week further time is allowed to file counter.
Mine.
Obliged. Item number 13.
Milords are fixing a date.
Yes, 1 week, 1 week.
My learned senior is on
I
other
was
matters.
thinking if your lordship calls it on 21st, there are other matters also, we could tag it up. Other matters where counters have been 21st. At 2 p.m. if your lordship grants it, other matters are there in a bunch lordship can take up.
Along with
I'll supply the numbers.
similar issues.
Yes.
Similar matters.
Similar issue, my lord. All similar issue.
Similar issues where my lords contracts have been signed and thereafter they have revised the my lords rates.
In my matter, my lords, agreement was signed after this order was passed by this honorable court. Agreement was signed. Now they are not giving me EY.
No, your matter is different.
Yes. All are on the same matter on additional charge. Leviability of additional charge.
Liberty to file a rejoinder to the counter affidavit in the meanwhile. It's so advised.
Yes, much obliged.
Great.
Much obliged.
Great.
Grateful.
Item 13.
My lord, I am challenging inaction of the OP number 4, my lord. Though I have completed the work within the stipulated time, but my final payment is pending. And I have also made a last representation under Annex 4, my lord, which is also pending before the said OP number 4.
What is pending?
My lord, for providing and sanctioning and disbursing the amount, which I have as
What
per
is
the
pending?
tender notice, my lord, I executed the work within the time, got the clearance certificate. But the final amount, which is near about 20 lakh, has not been paid yet.
Could have filed a suit. Or if there is any dispute, we could have filed gone for arbitration. Why have you come here? In the writ jurisdiction, what can we decide? Yes,
Take notice, your lordship, and
take notice, file affidavit. 4 weeks. So stop. It is observed that the amount which the petitioner is claiming is admittedly payable to him may be paid to him in the meanwhile. So stop. In any case, what according to the opposite parties are admittedly payable to the petitioner, the said amount should be paid to him.
All right.
Item 14.
May I please, your lordship? My lord, the petitioner took admission in BTech course in mechanical engineering under the BPUT, my lord.
Item 14. Yes.
My lord, the petitioner took admission in BTech course in mechanical engineering under the BPUT, my lord, in the year 2012. My lord, he has passed all the semester. But BTech is a 4 years course, my lord. He cleared all the semester in 5 years, my lord, by giving back paper. But my lord, they are not issuing the certificate, my lord. BPUT is not issuing the certificate. My lord, I have made representation and my lord, representation under Annex 3 and 4, my lord. Lordship with endorsement or postal endorsement, but they are not taking any action, my lord.
Issue notice. Issue notice. 1 week, 6 weeks.
Item 15.
My lord, petitioner made an agreement with the department under Annexure 1. Lordship may see he has completed the work, my lord. Thereafter, my lord, as per government notification, entire amount has been paid. I have received your lordship, but enhanced labor charges has not been paid. That's why, your lordship.
We go for arbitration. Why are you coming to the High Court?
All paid, my lord. Original paid order. Referring to the lordship.
your lordship, this relates to minimum wages. An entry 8 of Justice Arindam Sinha's court, your lordship.
Assigned to another bench. Minimum wages.
No, representation we will not do.
I filed an application before the
You
authority.
do whatever you want. The petitioners, the presentation application. It's one or two. I think there are petitioner in the presentation application are seeking direction to deposit party number 5 for payment of enhanced minimum wages as per the Gazette notification of labor so and so. So, the such question of dispute cannot be gone into in a proceeding under in a writ proceeding under Article 226 of the Constitution of India. So we accordingly dispose of the writ petition with an observation that the petitioner shall have liberty to approach appropriate forum or invoke any clause of the agreement in question in accordance with law. Application stands disposed of. All the cases same order.
Item 16.
Item 16, may I please your yourselves? In this petition, I have challenged the order of the OP number 2, that is the Chief Engineer, Building and Bridges, Rural Works, Orissa, wide Annexer 7, that my representation was.
What are you challenging?
The order, when representation I have filed and that was rejected. Cancelling my tender. Milord, the fact is, a tender was invited and by the OP number 3, and it was rejected as first tender was rejected as non-responsive, and the second tender was invited, and I emerged as the single bidder.
So they have cancelled.
They have cancelled, and I had approached this honorable court. And
so they have rightly cancelled because you were the single bidder. Single bidder cannot be.
Second time.
Second time, why have you not given that in your certificate that you had approached this court in WPC number so and so?
No, I have approached this.
What is no?
Milord, after I
look at your certificate.
Milord, I approached this honorable court and I was directed to file my representation there.
All right. No, you have given the.
Yes,
you have given it. All right.
Represented.
So representation dispose of.
And
that was rejected.
That was rejected. Again, I am before.
That is construction of canteen in the Bar Association.
Bar Association Kujang. Bar Association and hall. Bar Association hall and canteen. Milord, second time, I am the single bidder.
Yes.
Sputnik has similar matters pending. This cancellation of single tender.
No. What I beg to submit is, this is the second time, and OPWT code that when in response to a notice,
Mr. Naik's cases. Mr. Naik's cases, they were there yesterday, item 1.
First time. The tender shall be cancelled without opening the bid, and a fresh tender be invited publicly. If single tender is received, even after retendering, then the approval of the next higher authority should be obtained if the tender is otherwise be in order and acceptable. My technical bid is in order. And this
it does not compel the employer to accept. So if in the second tender only one bid is there, then they may not. that permits, that does not compel them. That is the law.
That,
The
this is the second time that they have already, nobody is.
financial. This is do you have financial rules, sir? OFR.
OJFR.
OJFR.
John matters on the same point.
My lord, single bidder, my lord, tender cannot be accepted. And the subsequent CEB, single bid, then they have to take permission from.
No,
the-
that is the rule, but I am saying, have we adjourned the other similar matters to another date? Because I think they were listed yesterday.
My lord.
So which date are they posted?
Monday.
देख ले, item 1 लगी कौन? Mr. Naik's cases.
Item 1, 10th August.
Four cases. 4-5 cases. Yesterday was there. Yuvraj Jain and. Yesterday's list.
No. Orissa financial rules.
We have an Orissa General Financial.
Orissa General Financial.
OJFR is there online. Monday is this. See the condition.
Application number 3248 of 2021. Application number 32480 of 2021. Letter 21/10/2021.
Decided on?
21/10/2021.
Why did you not mention it when we adjourned those cases to 13?
I have brought the order judgment because that is simply adjourned, that's why.
But this is that.
See, Mr. Counsel, your case is different. There were two tenders. First tender was cancelled, in which you had not participated. No one had participated.
No one.
Therefore, the first tender was cancelled. And there, in the second tender, you were the first, you were the only bidder.
Yes,
So therefore, that was cancelled. So that second tender, in fact, is a first tender for the purpose of cancellation of bid on the ground of single bid. All right. So your case is different. It is not that first time you had qualified and second time also you qualified, they were the single bidder. Therefore, so that is different.
First tender was not taken into consideration.
No, first tender.
He had not applied, nobody applied.
Yes.
First tender has not taken into consideration because it was not cancelled on the ground of the single bidder.
Right.
Rather on the ground that there was no bidder.
There was no bidder.
Therefore, it was retendered.
Retendered.
And in the retender, there was only one bidder.
One
It's not a case that there was first bidder and thereafter. So different.
First setting. It happens another time, then you have a.
Another time if you do.
Another time, even with single bidder, my lord, they have to take permission.
They have to take the permission, your lordship, from the company.
Liberty.
Take liberty from your lordship to make a prayer.
Like?
That item number 37, that teachers matter, 6 years benefit. We just want to make a mention that we have filed respective affidavits to delete that buyer's part. So your lordship can accordingly close the matter.
Argument has already been finished. You also only have, we had undertaken to file that memo. Supporting the affidavit to delete the deletion of that prayer.
The buyer's prayer we have deleted. We have prayed to delete it.
So what should we do now?
I think almost in all. Others will adapt it.
Yes, ma'am. Yes, ma'am. We have obtained instructions. This affidavit to be adopted in all my cases.
So we should decide your rest of the.
Rest of the prayers, I will not.
In this regard,
Can you file this in the
registry? Yes.
The registry?
Yes, we'll do that.
in this matter, some tax has been left out. Your lordship has passed interim order in some of the cases.
Subject to the outcome of the.
Subject to outcome of the bid applications. And in those cases, the interim application, their interim application has been allowed and the interim order has been passed. They do not want to proceed, press that first prayer.
That buyer's prayer, he also not pressed.
No. Prayer number 1, I do not want to press in this matter.
What is prayer number? What is prayer number 1?
Virus.
Virus.
That interim order I wanted to brought you because SOP has come on 22 and interim order has been called
Only
on the very next day.
Better to close it.
It has been stated that formal memos are going to be filed today online on deleting the prayer, whereby the virus of what?
More of the.
Odisha Group B, C, D, post repeal and special provision bracket and rules 2022.
Two has been challenged. So stop. Let it be done. Stop. The writ petition have been heard at length. Stop. The judgment is.
Only one thing, your lordship, some matters have to be detagged because that doesn't belong to the school and mass education department. So we'll give a slip for detag.
Have you filed the have you challenged the virus?
Yes. But
that is different.
My lord.
Give your slips, we will see. We will.
Yes, my lord.
So great.
All right, we will reserve it after. Let these matters come on record. This matter on Tuesday. Tuesday. So the matter will be Tuesday for formal order of reserving the judgment.
Detagging also on Tuesday, Your Lordship.
Detagging. Have you filed memo for deleting that?
No.
Then how can that be detected?
This is, my lord, they are seeking in these cases.
Counsel, have you challenged the virus of the rule which they
Yes,
have
my lord.
challenged?
Yes.
So how can that be detected?
Why is it different?
Because the SOP which has been issued and Your Lordship is.
SOP, that is a different aspect.
My lord.
That is a different aspect. Yeah, unless then you file an application or this thing, that you will not be pressing that relief.
All those applications, all those writ petitions, this rule is under challenge. Only difference is the department.
Oh,
Only difference is the department.
Because the SOP has not been issued in the Health and Family Welfare Department, in other departments.
okay.
The
Only
both
SOP is
which are
issued for
under
mass and school
consideration-
education.
Yes, confined to school and mass education.
My lord.
My lord is saying that is.
Just try to understand our difficulty. They have challenged virus. You have also challenged virus. They are saying that they will not press the relief for the virus aspect. You are not saying anything. You want the matters to be detected. So when your matters are taken up, then you will again press the virus.
Yes.
There is a small difference. They are claiming.
So therefore, if you want not to press that relief, you please file your memo. Then we may decide to detect.
My lord.
Are we clear?
They can file
My lord, my lord.
/registry.
online and it's work.
How is the online filing going on? What is the feedback?
Some problems are.
Mr. Santra?
Online, what my experience goes, my lord, it is going on. And after this physical filing, things are all being processed through online. So things are.
No, therefore, what
It will take little time, my lord.
it is taking time, but please,
Tenure I think it will be.
please, in fact, this much of infrastructure.
Yes.
I can tell you as the Chief Justice that there is nowhere in the country that you have 29 booths available to you where you may go with your brief and they are there to do everything rest.
We are getting accustomed, my lord.
So please, and we had in fact taken up the training programs also. We shall continue that. And subject to what happens in future, we are also taking steps so that the laptops are provided to the lawyers on subsidized rates. So
Welcoming.
this is what these are foundational things. So once you have a sound foundation, it will become very easy for you to develop further. Yes.
So great.
So that he'll intimate.
My lord, I have got the information. They have now, conundrum notice has been issued and we have added that. It's now issued, it's just a WhatsApp to me.
The date must be clear.
All right. So,
Up to 3rd of August, we have extended the date.
Extended the date.
3rd of
This
August.
is all known. So far as item 10 and 12 are.
council appearing on behalf of the DAVT has submitted that the relaxation in terms of marks scored by the candidates belonging to OBC and EWS.
Yeah, economically.
As provided in the INC guidelines has been taking into account guidelines. The DMET has, you grant approval, what do you do?
Yes, my lord, we have given notice so that they will apply for this students admitted.
Have permitted students who have been admitted in these colleges on that basis to appear for BSc nursing examination. So stop. In view of the stand so taken on behalf of the DMET, these applications stand disposed of.
My lord, we have extended time up to 3rd of August.
3rd of August?
Yes.
You have relaxed that semester?
Yes, my lord.
There was the last date fixed to 5:30. They have extended it to 3rd of August.
Disposed of.
Writ applications are infructuous, disposed of.
Writ application can be disposed
Nothing remains to
with
be
that direction, nothing remains.
And that is what also we have given a direction that all the institutions which have admitted students will allow.
Very good, very good.
We have given the instruction.
That's for everybody, not even
Not-
those who
not-
have
not-
applied. Very
For
good.
everybody.
Your lordships have
That should
issued
be.
a general direction, so that
we have
that
also-
basis there.
Not be.
Not only the aspect of the court.
Yes.
Item number 9.
Listen, item number 9, you also directed the collector, Noagar to join online. She was online, but suddenly she is offline, so try to contact she that there is some network problem. Now she is joined.
Sir, I am present, sir. Collector Neha Karius.
Which item?
District Election Office.
Yes, she had some problem, so from one room to she had to switch over to some other room.
What is the matter about?
My lord, this is regarding communication, minimum facilities to the villagers.
Irrigation or water supply?
No, nothing. No electricity.
What have you asked for?
No electricity, no water supply, no school, no
my
ASA
district election officer, district magistrate has not joined.
No, she is the district director. She was in her room. Because of network problems, she has
Sir, I have joined, sir. Sir, Collector Neha Karius, sir. I have managed to join, sir. I don't know if I'm audible.
You have joined.
We are confused.
And when did you join administrative service?
Sir, 2014 batch, sir.
2014. So you are not going to get better opportunity in your life than to serve the people in when you are in this position.
Sir.
So try to do something.
Right, sir.
So what have you planned?
Sir, as of now, sir, if I may respond to the matter at hand, sir, there is a bunch of grievances that have been submitted by the villagers, sir. We have an updated status. Unfortunately, I apologize, sir. We could not file the written response in that regard, but we have a status report on the presence of few benefits out of those that have been claimed that are not present in that area. But few benefits as claimed, sir, are actually not present in that area, like pakka roads, mobile connectivity, and electrical supply in street light is not available in that area, sir. We are making a plan, a saturation plan for both the villages, sir, and work will be taken up immediately, sir. Monsoon season, it is a little difficult to approach those areas also. So once the monsoon is over, sir, we will be in a position to take up these works, sir, and we will take it up on a mission mode, sir.
What about water?
Ma'am, water supply right now is there, but the water supply that is there, water supply, and is by, not by tube well, but by a pipe water supply to the household. So, ma'am, in one of the villages, work is already undergoing for that entire block to be connected by the village. Sadhuapalli village, ma'am. Sorry, the Salapganda and Mushuguda village, ma'am. There
How
it will
many
take a
villages?
little bit of
You have
time
raised
that,
issues regarding how many villages?
3 villages.
Three villages.
So 3 villages.
So there must be similar villages in the state of Odisha having facing same difficulties. In other districts.
Pipe water supply.
Since your connectivity is poor, we'll hear you on Monday. All right. In the meanwhile, we are not interested in
Right, sir.
affidavits. We are not interested in pleadings. We are interested in your reports and the work which you are doing. All right. It's a shocking state of affairs that there is a village which does not have electricity in 2024. There is
Sir,
a village which does
electrical
not have
supply
the
is there. Sir, if I may, sir, electrical supply is there, sir. They are talking about street light connectivity within the village, sir. But the households have electrical supplies.
household have
No room has been connected.
Madam, please verify. Please
Sir.
verify. We will take up the matter on Monday at 10:30. All right. In the meantime, please verify, and not only about the village. Use your resources to find out as to how many such villages are there. So let us begin from your district. And this PIL will not confine to these 3 villages. We shall like enlarge the scope of the public interest litigation for all such villages in the state of Odisha. All right. At least the basic facilities must be provided. It is initially when we had taken up the matter, we were not ready to believe what were asserted in the writ petition, that this can be the situation. So we are just adjourning the matter for Monday. In the meanwhile, you prepare a report, a genuine report. Don't be little scared of the fact that you are appearing before the High Court. The High Court has no interest in belittling any officer. We have interest in the general public interest, nothing else. So you just tell us what is the status, honestly, correctly, all right? And then we shall decide how to proceed. So you are facing a situation. The situation is not because of you. The situation is already there. The situation may improve because of you.
You have the opportunity to.
And that opportunity you have. So on Monday, we are just adjourning the matter. Tell us, and then if required, we will pass orders.
Right, sir. I will.
But you will again join on Monday.
Yes, sir. Yes.
List the district magistrate, Nayagarh, joined the court proceedings online.
Name.
Stop. Want to say something?
No. Our name has to be given also.
So list this matter on Monday to be taken up at 10:30 a.m. Stop. Considering the gravity of the situation, which appears to be prevailing in at least 3 villages of Nayagarh district as described in the writ petition, we require presence of the district magistrate Nayagarh online again on the next day. Stop. We expect the district magistrate to furnish the correct status of the facilities, lack of which has been alleged in the present writ application, by way by way of a report. Don't file an affidavit, just send a report, we will see. All right. We shall proceed in the matter, we must disclose that whatever report you submit will be part of the proceedings, part of the order. You are again.
Right, sir. I'll send a detailed report, detailed status report, sir.
And then we will proceed accordingly, point wise.
Yes.
Yes, next.
Item number 34.
May I take leave of the. Urgent matters will be listed on Monday and others on after a week.
There's two items, 50 and.
Just a minute.
50 and 11.
Just a minute. So such matters which according to you are urgent, just give the slips, those matters will come on Monday and other matters will come on the next week.
The one admission matter, press admission.
Fixed for 2
One
PM.
admission matter, press admission or lordship will take up tomorrow.
Just give this slip. All the matters where you want those to be listed on Monday, those matters will be listed on Monday. Other matters will be listed after a week.
Which can wait, please don't give memos, otherwise nothing can be taken up.